A man walks into court expecting to deal with a $10,000 bond. Minutes later, the judge uncovers a criminal history so serious that the entire case changes. What started as a routine DWI hearing quickly turns into a shocking reality check, one that could put this defendant behind bars for life. Watch closely as the judge explains why this case is far more serious than anyone expected.
Really, Harold? Okay.
There was a bond forfeiture this morning. You were in another court, so I'm going to recall the bond forfeiture. The current bond, though, is $10,000, I believe,
That's just tricky,
which is woefully inadequate for a person who is charged with a felony DWI in paragraphs 1 and 2. Then we have a conviction in 1997 in the indictment out of the 4th Judicial District Court of Wichita Parish, Louisiana. After that was final, according to paragraph 1, 2, 3, and 4. And again, the defendant, Nathaniel Clark, that's you. And you're here, Mr. West, your attorney and the state's attorney. But I'm reading through this indictment that was handed up in November of last year, a few months ago, by the grand jury. After that 97 felony conviction was final, it is alleged in paragraph 4 of the indictment that you committed the offense of aggravated battery, and you were finally convicted of that on May 4th, 1999, out of Wichita Parish, Louisiana. So, paragraphs 1 and 2 constitute a third-degree felony. Paragraph 1, committing the offense of operating a motor vehicle while intoxicated. But paragraphs 2 go on to allege that in 2012 and 2015, you were convicted out of Wichita Parish, Louisiana, of driving while intoxicated, operating motor vehicles while intoxicated. Those two priors and this new case together are a felony in the state of Texas because of two prior DWI convictions. And this constitutes a third-degree felony, which carries with it up to 10 years in prison if convicted. But paragraphs 3 and 4, alleging the convictions in 1997 and 1999, are in sequence. This makes this a habitual felon status, which means if convicted of this, you were facing a minimum of 25 years in prison to life. A minimum 25 to life. And the bond of what was it, $10,000?
Yes, right.
Woefully inadequate on a habitual felon status. Your bond is increased to $100,000 because of the serious nature of these allegations. If you post a bond, you must have a GPS device and you must remain in home confinement, and you can only leave your home for purposes of going to your doctor, going to your lawyer, going to get food, and those are to and from the most direct routes possible.
Your Honor, he also has a job as you think he worked for the city of Belsham.
Yeah, and going to and from your job in the most direct route possible. But still, you're going to have to post $100,000 bond.
Your Honor, we would request the lower amount. He's been to court every time. This is multiple times to be here. He's, like I said, he has a good job with the city of Beaumont. He has some sort of, I understand the issue about the alcohol. If we can put some kind of alcohol monitor or something like that on him, but he put him on the lower amount so he can continue to work, continue to do what he needs to do to take care of himself.
Anything
His
to
family.
say?
Judge, I think the bond that first off, the bond is inadequate. I agree at its current amount. I think the bond that you've raised it to is proper. It's in commensurate with what you've done with other people similarly situated. We agree with the conditions you said. I won't suggest anything lower. I did look on the system here, and I do see that at the time on which specifically he did have a lawyer representing Mr. Burbank on a misdemeanor offense that arises from the same incident, Judge. So that does explain the.
Well, I'm kind of disappointed that the lawyer wasn't aware that there was a felony offense pending, and he might not have been. But and you were sitting in a misdemeanor court when you should have been in here, but that's not fatal. And those things can happen. But everyone knows a felony offense where you're looking at a minimum of 25 to life is far more important than a maximum of 1 year in the county jail.
Yes.
1 year in the county jail is what you're looking at in a misdemeanor. Life imprisonment on this case. It doesn't take Einstein to figure out where the most serious matter is. But nonetheless, that's not a point here. That's not the point. Is the circumstances of this this underlying case with his rich criminal history, and then what was the blood alcohol?
157.
Yeah, 157. So that's twice the legal limit, right at twice the legal limit. And it's as though you completely forgot that driving a vehicle while intoxicated has its serious criminal consequences because you were convicted twice before of this. When but you were on a motorcycle and crashed your motorcycle.
That's correct, Judge.
Correct?
Yeah. Yes.
So you're out at Cardinal and Finette, a major area, at 11, well, at midnight. This at midnight. And you were honest about it. 3 16-ounce buds is what you admitted to, which may or may not have reached that high level. And then they brought you to the hospital to get a blood draw. And while they were trying to draw the blood, you were fighting them.
That's
They had
correct.
to put you hand restraints to allow the nurse to draw your blood. You kept resisting from the requirement. It was a search warrant, a court-ordered search warrant that you were objecting to, which is a crime in itself.
That's the misdemeanor he was dealing with, Judge.
And it says a check of his criminal history revealed he was on parole for a DWI 4th conviction. I don't even see that 4th one.
What we were able to obtain is the two that's in your indictment, but that's the information from the PC judge.
Okay.
Is that apparently he was on parole at the time of this offense. All of which are factors that the state urges that the bond stay at the amount you've set this afternoon.
All right. Okay. The facts show that this is another, there's not much we can really do to prevent him from jumping on a vehicle, a motorcycle, or a four-wheel vehicle intoxicated. He's making it a career of this. But most importantly, it's your consistent pattern of refusing to follow the rules. And when we're talking about motor vehicles, when the people die every day in wrecks for recklessness or negligence in the operation of those vehicles. And that's why the laws are important. These are vehicles are 4,000-pound missiles, nothing more, which can do great tissue damage to people, much less kill them. And motorcycle as well, when it's handled irresponsibly, that is intoxicated and recklessly, it's a danger to you and others. But you have a consistent pattern of not being empathetic toward others. You got to share the roadway responsibly with other people, not recklessly and negligently and irresponsibly. We all have kind of a agreement that we've all reached when we get on the road that we will handle our vehicles responsibly, not only for ourselves, but the other people who rely on us for responsible use. And you don't seem to care about others, much less handling yourself responsibly. So that is the reason for the bond. It is raised for those valid reasons, and we'll put it on the trial docket. You want to try it? We'll try it. And you're looking at, once again, be mindful, no less than 25 years in prison, to life in prison. The minimum is 25. And I can tell you the way the juries are, they won't find your criminal history amusing. That is all.
A single decision to drive intoxicated can change a life forever, but making that same mistake again and again can lead to consequences most people never imagine. What do you think about the judge's ruling? Was the bond increase justified? If you enjoy real courtroom moments, legal analysis, and powerful case breakdowns like this, make sure to subscribe and turn on notifications. We upload new courtroom stories regularly, and you won't want to miss the next case that leaves everyone in the courtroom stunned.